The other one is you can just give it away to your loved ones, your deserving descendants who are there, you know, with their mouths open like the baby birds waiting for the worm to come in. You can go ahead and do that, but if you do it, how are you going to transfer it? In trust. And what kind of trust? A grantor trust, exactly. You could also fund a trust to do an installment sale. Now, we know the law out there is that you need seed capital equal to 10% of the amount of debt that's going to arise. So if you have a client with a $50 million business, you got to have $5 million in trust. Maybe you can use guarantees, maybe you can use other things, but the bottom line is now you can put $5 million, and if you're married, you could perhaps put $10 million in there, and you could do an installment sale, therefore, of $50 to $100 million, and follow the law of the 10% seed capital. Let me mention, however, not everybody has a $5 million exemption. Why don't they have a $5 million exemption? Because of prior gifts, exactly. So you may only have $4 million. In fact, if someone made a gift between September 8th and December 31, 1976, it could even be slightly below $4 million. So don't tell your clients, oh, you can give away 5, give 4. Make sure you get the prior gift tax returns to see exactly what's going on so they don't come back and say, gee, I'm now told I actually owe some gift tax. Now, there's a better way, I think, for us to do it, and I want to go back to 1916 when the estate tax became part of our tax system. Congress made some keen observations. One of the ones they saw was that, well, gee, if there's no gift tax, and there was none, and we only have an estate tax, people will give away their wealth immediately before they die. So that's how we got the transfer within 3 years of death rule, which we, in effect, still have today. That was pretty simple. But Congress made a couple of other observations about human behavior. One was people do not like to give up their wealth during their lifetime. Now, they just don't like. Everybody here has been taught the same thing since you were old enough to understand. Your mission is to accumulate as much personal wealth as possible. And the estate planners come in and say, oh, Laird, that's wrong. You need to give it to your daughters. You need to get it to your grandkids. Go, wait a minute. What if I need that money? So one of the things they said is if you give something away during your lifetime, but you retain the right to the income or use or benefit from the property. By the way, even if there's just an implied, non-legally enforceable understanding, it's going to come back into your estate as though you never gave it away. And that's Section 2036A1, of course. The second thing they observed was that people, the next best thing to owning money is controlling it. Bill, what is the golden rule?
Let me consult with my legal counsel.
Well, no, right.
He who has the gold.
He who has the gold makes the rules. And everybody thinks it's doing to others. No, that's not it. She who controls the gold makes the rules, and that's critically important. I know, for example, if I gave all my wealth to my kids, you know what my next stop is? The nursing home. I mean, that's it. But when they know you control it, and I could give you lots of examples of it, and nobody in this room is selfish, but I actually know people who are very, very nice to older relatives just to make sure they get their inheritance. So in any event, Congress made those observations, so they put in, you give it away during your lifetime, you can control who gets it, even if it's not for yourself. It's back into your estate, and there are 2 sections which do that, 2036A2 and Section 2038. Well, lawyers, being conniving as we are, said, we can fix this. And in the 1930s, 2 of the Lehman brothers went to the same lawyer, and on the same day, using the same property, brother A created a trust for brother B, and brother B created a trust for brother A. And then brother A up and died. And he took the position, the trust that I created for my brother isn't in my estate because I didn't retain any control, I wasn't entitled to the income. And even though I'm entitled to the income and have control over the one that my brother created for me, I didn't create it, it's not in my estate. The IRS said nothing doing. This reciprocal trust doctrine, which developed actually under the creditor's rights theory, said you can't do that. What we're going to do is going to uncross those so that brother A was treated as though he had created the trust that his brother B had created for him. Now, by the way, that was at the tax court, but eventually it was adopted by the Supreme Court in a famous case decided in 1969 called Estate of Grace. Mr. and Mrs. Grace, on the same day, using the same trustees, the same lawyer, the same property, created trusts for each other where Mr. Grace got the income from the trust that his wife had created, and she got the income from the trust that he had created, and Mr. Grace up and died. And the Supreme Court said, no, the reciprocal trust doctrine does apply for estate tax purposes, and therefore the trust that Mrs. Grace had created for her husband was included in his estate because he was treated as though he had created it, because he had created a substantially similar trust for her. By the way, for those of you who are Catholic, I don't want any confusion. That case is a state of grace, not state of grace, okay? Just don't want any confusion on that point. So the lawyers tried to beat it by the reciprocal trust doctrine. Now, the other thing the lawyers tried to do is say, well, look, here's what we'll do. I'll have my client create or settle a trust for herself, but she won't be entitled to the income. We won't make regular distributions, and we won't give her control, yet she'll still, through the trustee, have access to the property, and we can keep it out of the estate that way. But we had a problem in the United States, and that's creditor rights. In every state in the United States until 1997, there was a rule. If you create or settle a trust for yourself, a so-called self-settled trust, even if you're not entitled to the income, even if you're not entitled to the principal, you're only eligible to receive it in the discretion of a truly independent trustee. No prior understanding, no winks, no nothing. And in fact, even if you never get anything, your creditors forever have access to the property. Why? It's just a rule. And so that was used for tax purposes. Beginning in 1941, in a case called the State of Herzog, decided by the Second Circuit, Judges Hand, including Learned Hand, and Judge Swan, they said, yes, creditors' rights can cause the asset to be includable back into the grantor's estate because he can relegate his creditors to the asset of the trust. Something happened in 1980 that really made me start to think, however. There were foreign jurisdictions, places you can't find on a map, like Mauritius and Vanuatu, passed laws saying, Americans, you can come to our country and create a trust for your own benefit, a self-settled trust, but under our laws, the assets are not going to be subject to the claims of your creditors. And trillions of dollars have gone offshore. But in the early 90s, the IRS said, by the way, if you create one of those trusts, because creditors can't get it under governing local law, it won't be in your estate when you die. And I said, well, gee, this is a great deal. And I must have had 10 trust companies from various jurisdictions come in and tell me how great these were. But you know what I worried about, Diana? I worried about the fact that those assets were going to be sitting in one of these places that you can't find on a map. And in fact, I had a client who actually created a trust in Vanuatu and moved there. And by the way, he lost 90% of his assets when the government was taken over in a coup. And he was almost killed. And I had seen that actually happen. I said, I'm not going to have it happen. I said, let's get a state in the United States to pass a law saying if you come here and you're not trying to defraud your creditors, you can create or settle a trust for yourself, a self-settled trust, but it will no longer be subject to the claims of your creditors. I went to my brethren in New York, and they said, you want to do this? And you also want to repeal the rule against perpetuities? What's next? Reintroduction of wife beating? I mean, it was unbelievable. They couldn't believe it. This stuff was sacrosanct impossible. So, you know, I had gone through this baloney with my New York brethren before, and it's taken forever to get them to do stuff. But I was up with my brother in Alaska fishing with a friend of ours, Dick Thwaites, who's a member of the American College. And I was telling him how I'd come up with this idea, but, you know, it was rejected. He said, if you'll draft those laws, we'll pass them in Alaska. So on April 1, 1997, Governor Tony Knowles, not as pretty and not as well known as Sarah Palin, I'll admit, but Tony's a bright guy, graduate of the University of Virginia. Tony signed into law the Alaska Trust Act, which was a real revolution. And we now have about 15 states, including Florida, has a little piece of self-settled trust law. So if a husband creates a Q-tip trust for his wife, and when she dies, even if it automatically reverts back to a trust for him, it's protected from the claims of creditors under Florida law. Now, I tried to get the IRS, after that law passed, to rule that if someone created a self-settled trust in Alaska, that it would not be includable in her estate unless there was some implied understanding or a wink-wink deal like that. And the IRS eventually called me and said, we're not going to rule. And I said, why not? They said, because it's hypothetical. I said, what's hypothetical? Whether your client will die. I said, I'm going to go way out on a limb here, and I'm going to make a factual representation. My client will die. But they said, we know that, but it's too good a deal. We're not going to help you. We know this works, but we're not going to tell you. But then something extraordinary happened in 2004. The IRS came out of the closet with Revenue Ruling 2004-64 and said, if you pay the income taxes on income attributed to you from a grantor trust, you haven't made a gift. IRS in 1994 issued a private letter ruling and said, if you paid the income tax on the income imputed to you under the grantor trust rules, you made a gift to the trust because the trust was getting the income and you were paying the tax. And I wrote a letter to the IRS and I said, if a taxpayer took a position that ridiculous, you'd either have her charged with fraud or you'd have her put into an institution for insanity. A week later, they withdrew the private letter ruling, but it took them 10 years to come out. But there was one other key element. In that, they basically said, if your creditors could not get at the assets of the trust under local law, the trust would not be includable in your estate if you had no entitlement to reimbursement for the income taxes paid. So we reapplied to the IRS and said, okay, boys and girls, it's time now to come all the way out of the closet on self-settled trust and issue us a favorable ruling. And the IRS, at the end of 2009, issued 2009-44002, a very, very important ruling. And I have my dear friend Diana Zadel to thank because it was not as clear as Diana suggested they make it, and they agree. This is a quote. The trustee's discretionary authority to distribute income principal to the grantor does not by itself cause the trust corpus to be included in the grantor's gross estate. Now they go on, however, if we find there was a deal, because all you need is an implied understanding that's not necessarily legally enforceable, we may claim it's back in the estate. But if your client, or you, if you create a self-settled trust, view this as the trust of last resort. I'm going to have to spend all my other assets before I go to the trustee and ask for something, then you're going to go ahead and have exclusion. By the way, don't think that the IRS just knee-jerk gave this. This went up to the highest levels of the Internal Revenue Service, and they issued this ruling. And again, I know it's a private letter ruling. I am confident, by the way, it is right. In fact, when we first submitted it, the IRS called back and said, we don't know if we should issue this ruling because we view it as a comfort ruling because the law is so clear. And I finally said, look, you got to get it. Go back and look what you did in 1998 to me, and now you've got to go ahead and do it. And they went ahead and they issued the ruling. By the way, there are now, as I say, 15 states that permit self-settled trusts to be created that are not subject to claims of creditors. The only 2 states where this is likely to work is Alaska and Nevada. The reason is all the other states, like Delaware and like South Dakota and like Wyoming and like Utah, have exceptions. Some creditors can get at the assets of the trust.